Dear sisters and brothers, in the church there are leaders or superiors at various levels. Every superior must fulfill his or her task diligently in accordance with the law. Sometimes some people expect them to consult them or get their consent or just treat them as equals all the time. That is not always possible. Each and every superior is by law entrusted with certain duties and rights. Certain things they must be able to do on their own. Otherwise, there is no meaning in their being appointed or elected as superiors. So, first of all, we all should understand that each and every superior can do quite a number of things without reference to anyone. In this context, we should think of the Holy Father, to whom the Church recognizes supreme power, full power, immediate power, universal power, ordinary power, and that is also proper power in accordance with Canon 331. So it is for him to do everything in accordance with his conscience, in accordance with the law, for the welfare of the church. Again, it is for him to decide when he wants to act collegially together with the other bishops, or it is for him to determine whether to act personally on his own behalf. With regard to other authorities in the church, there is always a limitation. With regard to the authority of the bishops, the 1917 code made them dependent on the supreme authority or the Roman pontiff for so many things. But then the new code, in accordance with the principle of subsidiarity, gives them greater autonomy in deciding those things that are regularly needed for the people of God entrusted to their care. Canon 381 uses the following adjectives while describing their power. Their power is ordinary, that is attached to their office. Their power is also proper, they exercise it in their own name. Their power is immediate, they can directly exercise their power, or if they want, even through others. Canon 391 speaks about their power of governance. They have legislative power, that is power to make laws, of course, without contradicting universal law. They have executive power, that is power to enforce the law. And then they also have judicial power. While they cannot delegate legislative power, they can always delegate executive power. They can exercise it through the vicar general or other priests. They can directly exercise judicial power. Normally, they exercise judicial power through the judicial vicar and the judges. Thus, the power of the bishop is very clearly described in the law. With regard to the vicar general and episcopal vicar, they do not enjoy legislative power or judicial power, but then they have the same executive power as the bishop except those cases which are reserved by the bishop to himself. Even the bishop is limited in the exercise of his executive power in certain things, like he is dependent on the College of Consultors, on the Diocesan Finance Committee, and also he is dependent on the Senate or Presbyteral Council before making certain decisions. So, all kinds of superiors must follow the norms laid down in the law, maybe universal law or particular law. When they need to consult, Canon 127 says, if the consultation is obligatory, omitting the consultation will make that particular act invalid. It does not matter that they go against the consultation at times because of certain serious overriding reasons, but they are not allowed to omit the consultation altogether. For instance, the diocesan bishop is asked to consult at least in 7 instances the Senate or the Presbyteral Council before proceeding with certain actions. If a particular bishop omits consulting the Senate in these cases, the actions will be canonically invalid. The bishop is required to get the consent of the College of Consultors and also the Diocesan Finance Committee in certain financial matters. For instance, for questions of alienation and also for certain extraordinary administration. That means, suppose there are 10 consultors or 10 finance committee members, the majority, at least 6 of them, must approve that particular act. Otherwise, the bishop will be acting invalidly. Thus, there are 4 different stages of a superior's acting as superior. First of all, he can do certain things personally. Secondly, he can do certain things only after consulting, that is, getting the counsel or getting the opinion of the person or persons concerned. In this case, he is limited to some extent. Normally, a good superior in questions of consultation goes by the majority. Only when there is a serious overriding reason, he can always decide otherwise. And then in the third case, that is, when he is required to get the consent, he cannot act validly unless he got the consent of that individual, or if it is a college, he got the consent of the majority of that college. Then finally, the superior may be acting as one among the group in certain cases. In the case of the diocesan bishop, he never acts collegially within the diocese. But then, in the case of the superior general of an institute of consecrated life or society of apostolic life, that is, religious institute, secular institute, or society of apostolic life, they act collegially in the universal law in accordance with Canon 699 when it comes to the dismissal of a member of that particular institute or society. They act collegially. The superior general needs to have a minimum of at least 4 counselors. He can have more also, but not less than 4. Together with the superior general, there should be at least 5 who are voting, and all are equal in this particular case. Other than this, the constitutions may also have other collegial acts, but in the universal law that is not mentioned. But always when there are many more collegial acts, they need to be approved by the competent authority. Then only the constitution will be effective. It is to be noted that people should not always think that every superior must get their consultation or consent for each and everything. Still worse, they should not think every superior must act collegially in all the cases. But all superiors are asked to remember that they should exercise their authority always in accordance with the general law or universal law, and also in accordance with their own law, that is, in the case of the religious and others, their own constitutions and directories, and then preserve the dignity of each and every individual and guide the members of the people of God in accordance with the gospel. Thank you.